Summarize.
Thank you, Mr. Chairman. Before I get into the summary, I do want to acknowledge that once again, it points to the importance of the letter of intent and the procedures that will be followed pursuant thereto relative to water, because I think you all know that one of the requirements of the letter of intent to be followed by an IGA is a public water supply from the village of Lake Zurich immediately, not waiting another 6 years, but immediately, because Hawthorne Woods will be required to waive its opposition to that water connection. The evidence presented by the Village of North Barrington and by Hawthorne Woods, and also the evidence presented by Acre, conclusively proves that the Dimucci proposal, as provided to you, is not appropriate for this site. We agree with the legal expert presented by Acre. My friend of many years, Sam Masusa, and please note that I am not referring to Mr. Masusa as my old friend. We agree that with over 50 years of municipal practice that each of us have had, we have never participated in or observed commercial rezoning without plans, engineering information, traffic information, and other details which are essential. All this is lacking in the original proposal of the developer. And in the developer's request for rezoning as originally presented, it is therefore fatally flawed. Does this proposal compromise, however, this proposed compromise as set forth in the letter of intent, does that cure this defect? We believe it does. The letter of intent specifies at the bottom of page 3 and the top of page 4, and here I quote, "The county and the villages will enter into a binding three-party intergovernmental agreement, IGA, concurrently with the county board's consideration of the project's pending rezoning, conditional use permit, and PUD preliminary development application to effectuate the terms of this letter of intent. The county and the villages will use appropriate legal mechanisms, including but not limited to a consent order entered by the Circuit Court of Lake County to bind the county and the villages to the terms of the intergovernmental agreement for a period of 99 years. The normal IGA is 20 years, but using the court mechanism, as in the prior IGA, it's extended to 99. The letter of intent thus provides the glue to salvage an otherwise incomplete petition for rezoning relief. Lee Brown and Tester Associates provided evidence that the Dimucci proposal as presented is flawed and does not meet the legal requirements for rezoning and for a PUD. Mr. Brown also provided the legal foundation for you to recommend zoning based upon the letter of intent. Mr. Brown stated, "The single message and strategy of the implementation plan is cooperation between municipalities and cooperation between the county and the municipalities. The specifics as to use of the property and the protections spelled out in the letter of intent to be implemented by an IGA approved by Coy Court give all of us, as you, as the ZBA, the county board, the villages, and the citizens, protection. Likewise, Andrea Pratt, the village engineer for the village of North Barrington, testified as to the unique problem of the village of North Barrington relative to drainage, because almost all of the runoff from this property drains into North Barrington and the very sensitive Flint Creek, running first through Windstone subdivision immediately across the street from the development, and then under Miller Road, which regularly floods as it is, and then through the heart of the village, the Biltmore subdivision, before going into Grassy Lake, into savannas and other sensitive wetlands and ecological jewels before finding its way to the Fox River. Please note that the letter of intent meets the challenge of controlling this runoff in several ways, including limiting the runoff to a specific number of cubic feet per second and precluding use of the site for certain activities which would involve the storage of gasoline and other petroleum products. The executive director of BACON, Janet Aguiletti, just testified most effectively as to the groundwater concerns and other matters that must be met and will be met by the IGA with water coming from Lake Zurich. And she certainly demonstrated her expertise in these matters. She pointed out the problems and dangers of serving the Dimucci property with its own well, and why, again, in that connection, the letter of intent and the subsequent IGA are vital. You will recall that the property may not be served with Lake Zurich water for the 6 years, as the chairman has already pointed out. Hawthorne Woods, as I mentioned a moment ago, has agreed to waive that prohibition. Ms. Aguiletti pointed to the significant dangers of multiple private wells in the area from allowing a shallow well to serve Dimucci, even for a short period of time. Mr. Chairman and ladies and gentlemen, I believe that the village of North Barrington has made a compelling case for the denial of the Dimucci project as presented and for acceptance of the Dimucci proposal as set forth in the letter of intent. Thank you.
Thank you. Does the board have any questions with Mr. Braithwaite?
No, I don't.
Al?
No, thank you.
Carol?
No, except thank you for a very informative information.
Bob? Dennis, you got anything? No question.
Just wanted to clarify, Mr. Braithwaite. Did you say that Hawthorne Woods has opted out of the portion of the agreement that required the municipal water be, or the water be required before the development starts?
That is correct. In fact, it even before the development starts, it specifies that Hawthorne Woods will immediately agree to the use of Lake Zurich water, which is now prohibited by reason of an IGA between Lake Zurich and Hawthorne Woods. That is to be waived, and a very vital provision is being waived as part of the letter of intent and the future IGA.
Thank you.
Yeah, I do have one question, sir. Not being a lawyer, a consent order for the Circuit Court of the County of Lake, binding the village and the county for a 99 period. Help me understand. To me, that says that whatever conditions the PUD that is being requested, those conditions would be in place for a period of 99 years, and would they be able to be changed in any way through any action of the county board?
The county being a party to the IGA, and upon it being accepted in a consent order involving all the property owner and the three parties to the IGA, would it be binding for the 99 years? It could be changed by agreement of all of those parties. That's the case in the present IGA, which is between Hawthorne Woods and North Barrington, which is also for 99 years and been endorsed by a court order. Part of the letter of intent is that that present IGA will be removed and actually repealed and replaced by the new one. But that is the intent. And then one of the significant parts of this is we haven't touched on, but I think it's been mentioned, is that the IGA, as well as the letter of intent, provide for revenue sharing between the county, the Hawthorne Woods, and the village of North Barrington, which is based on the very simple principle that Hawthorne Woods will receive a significant negative impact from any development just because they're there and there are roads in the vicinity. North Barrington likewise will receive a significant negative impact from even a reduced scale mall, and I've already mentioned the water, which is so critical, as well as the increased traffic that will come through the village. Those are burdens that those villages will have to meet and provide revenues to solve. And that's the basic reason for the revenue sharing.
Thank you.
Al?
I have a quick question. Can I just jump in here for a second for further clarification?
Introduce yourself, please, Mr.
Certainly.
Shapiro.
Thank you. Thank you for the reminder. I'm Dan Shapiro on behalf of the Village of Hawthorne Woods. What typically would happen in a case like this, to answer your questions, is the parties would take the IGA and literally attach it to a court order. So it would, the court order would say, see attached IGA. And that way, that gives a court of law enforceability over those terms. So it would be enforced by a court and also by the parties by way of contract.
I have a question. Yeah. Now I know that the village of North Barrington has had some of the finest witnesses that I have heard in a long time, and I really appreciated you having them here. But hearing their testimony, it almost comes to the point that 650,000 square feet of building space would be too large for this property, what I heard. But I know that the villages are in favor of reducing it from the proposal of 800,000 to 650,000, but what I heard is that the 650,000 may also be too large for the site. And I'm a little confused, but the village is okay with the 650,000 now.
We draw a distinction. We draw a distinction between 450,000 of true commercial with limitations, yes, but the typical commercials, and 200,000 which would be more of a neighborhood type uses, local smaller restaurants and so forth. Those have a much less significant impact on all the communities than the 200,000 of great commercial, if you will. The 400,000 could be much more intense commercial, still limited by the restrictions against certain uses, such as tattoo parlors and uses involving petroleum, such as gas stations and other petroleum products, and still having other limitations. But the 200,000 is a much less intense type of use. And that's what was being contemplated. Certainly North Barrington would like to go with the kind of square footage and uses that we had in an IGA between North Barrington and Hawthorne Woods in 1999 and 2002. However, and this is where we come to a big however, it is not 1999 and it's not 2002. It is a number of years later, it's 10 years later. And also, we believe we have to be realistic in looking at the total circumstance, looking not only to what we believe this ZBA would do, and we have confidence in this ZBA, but we have to look beyond that to what the county board, which comprised of people from all over the county, and ultimately, and most importantly, ultimately, what a court might do. I've been practicing law long enough that I'm not going to predict what a court will do, and that's the vice of the problem.
Thank you. That was a good explanation.
Any other questions from the board? Dimucci, do you have anything for Mr. Braithwaite?
No.
Questions? No? Thank you. Anybody in the public wants to cross-examine Mr. Braithwaite? Yes, ma'am. Did you fill out a form? I believe you did.
Yes, sir, I did. You hadn't found it the other day, but thank you. I appreciate the opportunity.
Did you introduce yourself?
Yes, I'm going to do that. My name is Deborah Barry. That's B as in boy, A-R-R-Y. Deborah, D-E-B-O-R-A-H. I'm a resident of Deer Park since 2003. Lake County almost all my life, and I'm the press secretary for Deer Park Neighbors, which is a community action group that's been blogging and participating in issues like this since 2006. I don't know, well, I would like to ask Mr. Braithwaite or Mr. Shapiro and somebody's cell phone's up here, by the way, if you're missing it. What I would like to understand, a short answer would be fine. I have 4 or 5 quick questions. Many of us in the public cannot understand, certainly we agree times have changed since 2002, but in the first place, I'm not hearing any agreement among the public to a compromise at all, especially a compromise that did not involve acres, Citizens for Conservation, etc. However, I feel that this, to some extent, is a camel is a horse designed by a committee. I do believe everybody was in goodwill to do the best they could, but what the public was asking for is input. My question is.
You got a question?
Yes, I have some. No, well, because I needed to. I was trying to narrow it. I think I inadvertently broadened it. I apologize. How is the county able to override the previous boundary agreement and IGA, and I believe there was a previous court order? That's a question that has never been asked, and we have one of the most esteemed village attorneys here, and no disrespect to you, Mr. Shapiro, either, but I think the public deserves a short answer to that if it's possible. Thank you, and then I have a couple of other quick questions.
I thought you would know by now that you do not expect to get a short answer from a lawyer.
That's why I dropped out of
But there is a really pretty simple answer to that, and it goes to the heart of the new proposed agreement and compromise. The IGA was between Hawthorne Woods and North Barrington. The county at the time, we felt, endorsed that IGA, supported it, but the county was not a party to it. They should have been, but they were not. That's a fact. So the county is not bound by it in any way. And when the developer came along and went to the county and said, my property is under county jurisdiction, not municipal jurisdiction, the county had every right, in fact every duty, to listen to the developer. That's why it's very important that the new IGA will include the county as well as the two villages. That's as short as I can make it.
I appreciate that answer. And it brings me, if I can, a related point of fact. I believe it was Tuesday, and it's been referred to before, that Deer Park Town Center was another example of zoning in advance of a development. It would take many FOIAs, but I can tell you from looking at the 1991 zoning map that, in fact, let me restate this. The comprehensive planning process in the village of Deer Park, and Deer Park is now almost 60 years old. It wasn't on the map perhaps until the town center. The process of comprehensive planning preceded, before Deer Park Town Center was a twinkle in anyone's eye, goes back at least to the mid-'80s. Secondly,
Do you have a question?
Yeah, well.
This is not the time for public comment.
All right, sir. I was trying to create, I said I had a point of fact to correct something that I think is in your board's interest to know. But if you don't want to hear it, I will email you.
You can make that when you have public comment.
Okay, I'll be happy to come back. On the letter of intent to both villages, and again, with due respect for very hard work, did you consider, the letter of intent appears to be a compromise on the flawed Dimucci proposal. Was there any thought of other kinds of uses? For example, pervious surfaces in the parking lot instead of impervious surfaces, underground parking instead of two-story parking. I mean, you did an excellent and most important video gaming, which will be approved next month in Lake Zurich. I would be very concerned, and since there's two municipalities and the county involved, very concerned about the possibility of video gaming at this site. So if it's appropriate, just to understand the letter of intent and the tremendous time you guys, job you did in a short time, it addressed only the Dimucci proposal and compromises on that. Is that correct? Is that the process? That's how they say it. Did you consider anything other than the Dimucci proposal, and of course I'm representing your own villages, in this compromise? It doesn't seem to be a compromise, it seems to be a rework, to my mind, an excellent rework of the Dimucci proposal. And one of the big problems we've all had in the public is the extensive amount of Lake County time that was put into preparing this proposal. So I think it's more of an improvement than a compromise. I would just like to have you reflect on that, and again, with respect.
Well, it seems like there were many questions, but I think the basic question is, did the villages and the county consider a broader IGA and other entities? The two parts of that answer. First, an intergovernmental agreement by statutory definition is an agreement between governmental entities. It cannot include non-governmental parties. Secondly, as to what area was being considered, I was not personally part of those discussions, but I am certain that the focus was on the problem before us. We have enough problems in the world to solve without trying to solve other than one that we're dealing with, which is the effect of the Dimucci proposal on the communities. And that was what the IGA will be addressing and what the letter of intent addresses. I don't know that I can answer.
No, that's, thank you, that is an excellent answer, and I appreciate it, one I had not been able to get to on my own. The last matter that would be a question, I believe, instead of a comment, is how do we know the Lake Zurich water, obtaining the potable water, the municipal water from Lake Zurich? Water is a closed system. What studies or assurances does this board have that the gallons per day will be available, especially since you're moving up the date of that agreement, and Lake Zurich is in the process of a substantial downtown redevelopment of its own? So have we really looked at the total gallons available? Water is a closed system.
I think that's really a question for Lake Zurich, but I can say that there is in existence, as of the fall of 2010, a written agreement between the Dimuccis and Lake Zurich, whereby Lake Zurich agrees to provide water to this property when the present ban imposed by Hawthorne Woods is lifted.
Thank you. Staff, Eric, does staff want to expound on that at all? I mean, I think what I read was that there is an agreement between the Dimuccis and Lake Zurich, and there is plenty of water available.
I have Mr. Chairman, I have Gordon White from Lake County Public Works preparing to approach the podium.